Hey gang! Welcome to the very first episode of Kiff Says, a place where we'll break down the legal aspects of your creative business, and I'll try to convince you that the law doesn't have to equal scary. Today, I want to talk about collaborations. The beginning of a collaboration is magical and so exciting. You can't wait to jump in and get started. But I encourage you to have a couple tough conversations with your collaboration partners before you begin work. One of those conversations is, how do we deal with this intellectual property? You're creative people, so you're going to be coming up with things that are covered by the Copyright Act, that are copyrightable. So how does the collaboration deal with that? How is the collaboration able to use that intellectual property? One way that you could do it is the collaboration could license the copyright. Your collaboration could take something you've already created and it could be licensed to the collaboration for the collaboration to monetize and make use of. This can come about, a common way that this can come about is when you've created something beforehand. Say for example you're an illustrator and you love to sit in the studio and draw and you hate to do all the business side of things. I'm sure that's not any of you out there. So maybe you team up with a collaboration partner who loves that book side of things, that loves the business side of things. The collaboration is going to license the copyrights that you create, and together you're going to be able to monetize them. You get to sit in the studio and do what you love. She gets to handle the business side and help a creative person and do what she loves. That would be a great example of how collaboration would license a copyright. Second thing that could happen is it could be considered what's called a collective work under the U.S. Copyright Act. Again, this often comes about when you've previously created things. Say, for example, I take my photographs and I team up with a poet, and we decide to create a book. She's written all of these poems already, and I've already taken the photographs. What we're doing is merging them into a book that we can both, as a collaboration, profit off of and sell. I want to keep the copyright in my underlying photographs and be able to use them in other ways. She wants to do the same for her poems. So we still, with a collective work, maintain those rights, but we merge them together for a specific instance and use them as a whole. This differs from our third way, which is called the joint work, because of our intent. The intent with a collective work is that they still are separate things and that we still can do things outside of the book with our photographs and our poems. With a joint work, the intent is for our pieces to be merged together and to always be shown together. A good example of this might be a lyricist and a musician getting together to write a song. They don't want the lyrics to be used with other music and the music to be used with other lyrics. And so our intent is for those to be interdependent and reliant upon each other and always be stuck together. And when this is the case, we've got a joint work. So next time that you embark on a collaboration, I encourage you to have this tough conversation with your collaborator and determine which of the three ways, if you're going to license, if it's going to be a collective work, or if it's going to be a joint work before you get started. So you can make sure that you're both on the same page and you have the same expectations and boundaries for your collaboration. So hop on over to the Artist JD to get these videos straight in your inbox. If you enjoyed this video, I'd love it if you shared it with your network. Thanks so much for tuning in, and I'll see you next time.